Hello. Now I'm going to take you through question 9 from the October 2018 exam to give you an idea of how I think it needs to be answered. As usual, there are no guarantees that the examiner would agree with me, but I don't think we're going to be very far apart. Let's start with a run through the facts, and I think it's very important when you look at a problem question like this that you start by looking at the instructions, which come usually at the end of the question. And you're looking for two things. First of all, who are you advising? And secondly, what are you advising them about? And here the examiner says, advise Erica, who is Beetroot's managing director, about what they can do under the Copyright Designs and Patents Act. So immediately, with your knowledge of the syllabus, you know that you have to write about design right and possibly copyright. What other facts are there? Well, the designer involved is French and goes under the unlikely name of Carrot. Carrot was an employee of Beetroot. We're talking about tableware here, and it was designed 8 years ago. We don't know for certain that Carrot was an employee when the design was created, so I might have to take a bit of care over how we approach this when we write the answer. We're told about 3 different features of the tableware. First of all, the shape, and in particular the oversized handles. And in a situation like this, bear in mind that we have several different designs for different items making up the collection or the set. We're told that the tableware is black in colour and it has on the surface a frosted pattern. Then we have 3 potential infringers. First of all, Fuchsia, who are producing articles with a similar shape, and we're told in particular that the handles are especially similar. We've got another defendant whose name I'm going to pronounce Ebe, but who knows, who seem to be reproducing the tableware in a very similar way, but they're producing them more cheaply and there is no pattern on the surface. Finally, we've got Geranium, who are making replacement saucers on the basis that owners of the tableware are going to break their saucers, but apparently nothing else. It's slightly surprising that it's not teapot lids, actually. Not only because in practice they are what gets broken, but also because Mr. Justice Laddie specifically talked about them in a case once. What rights are we going to have to write about in this exam answer? Well, the examiner helpfully directed you to the Copyright Designs and Patents Act, and I think you'll have noticed that design right is clearly engaged here, and that's going to be what most of the answer is about. It leaves the possibility that there might be some copyright. The product is mass-produced, so it's not going to qualify as a work of artistic craftsmanship. If the tableware was handmade, it might be a different matter. We've got no information in the question about the design process. Are there drawings? Is there CAD/CAM data on a computer somewhere? But if we have a design document, then section 51 of the Copyright Designs and Patents Act is going to apply, and making an article to the design that's embodied in the design document won't be an infringement of copyright. If the cups and saucers and things were themselves artistic works, and probably they'd have to be works of artistic craftsmanship, then section 51 might not apply, but that's not the case here. We'll come back to that later. Finally, we ought to consider the surface decoration. Could that be considered an artistic work? It sounds very mundane, and there are originality issues attached to it because Carrot copied it from a friend. The fact that the friend applied it in the motor industry rather than to cups and saucers isn't going to make any difference for copyright purposes, because you're going to look at it simply as a pattern without any specific application. So let's begin with looking at design right, and begin by considering the status of Carrot. And in questions about design right, the examiner always puts in a point about qualification. A few years ago they used to be much more complicated, so I think it's got a lot simpler in the last few years under the new examiner. Here Carrot is French. The design's going to qualify for protection because she's a national of an EU country. As things stand, incidentally, that's not going to change as a result of Brexit, but you certainly don't need that piece of information for your exam. In years gone by, the examiner would have been asking about Japanese or American or Australian artists, but it seems now to be nice and easy, and we don't have to consider whether, in spite of being a national of a non-EU country, they're nevertheless resident in the EU, nor do we have to consider the rule about first marketing, which incidentally also modifies the rule about ownership. So if you rely on the first marketing rule, it's the person who does the first marketing who owns the design right. So I mention all those points, not because we need them for this answer, but because you might need them for another answer. We're told that Carrot was an employee, and I think at this stage it's legitimate to say to the examiner, provided that she was an employee at the time that she made the design, Beetroot owns the design right. If she wasn't, things are going to get complicated, because we'll have to consider whether she was commissioned to make the design, and if she was, 8 years ago the rule was that actually it would make no difference, that the same rules would apply as if she was an employee, and the commissioner would own the design. But that rule was removed in 2014. Again, I mention these points because you might need them for a different answer, but you don't need them for this one. Next we've got to look and see whether the design is still protected by design right, or whether design right might have expired. We're told that the article was designed 8 years ago, or the design was made 8 years ago, but we're not told when articles were first placed on the market. And remember that for design right purposes there's this two-legged formula for working out how long protection lasts for. 15 years from when the design was made, or 10 years from when articles were first placed on the market. It's unlikely in practice that a design would be made and then articles not placed on the market for 5 years or more. Not with a product like this. But of course there will have been some lead time between the design being made and the articles appearing on the market. So possibly first marketing took place 7 years ago. Obviously we're still within the term of protection, but the important point here is that licenses of right are available during the last 5 years of the period of protection, whatever it is, or however it's measured. So if we're looking at, say, 7 years from first marketing, then clearly we're well within that last 5 years of the 10-year term of protection. If we're looking at 8 years from when the design was made, and I think it would be a good idea to tell the examiner that it's highly unlikely that this is going to be the correct measure, but if we are, then it's possible that we're not yet in the last 5 years of protection. And the importance of licensing of right I'll come back to later. The next step should be to tell the examiner about what design right will protect, what elements of the design might receive protection. And you start with the definition of the design from section 213, features of shape or configuration of the whole or part of an article. So definitely the shape of the cups and saucers, definitely the distinctive, well, that's not an important word for design right purposes, but distinctive shape of the overlarge handles, and each piece of tableware is going to be a separate article. The whole service is not an article, it's a number of articles. And designs are going to be protected provided they are original. That's the requirement in Part 3 of the Copyright Designs and Patents Act. We're not told much about the originality of the shapes themselves, but we are told about the originality of the handles. Tell the examiner that the courts will apply a copyright style originality test. They'll look to see whether copying has taken place from earlier designs, and that designs aren't considered to be original if they're commonplace. Here immediately we can tell the examiner that there's an issue with the handles, not because they're commonplace, but because they're not original. The only reason they're there at all is that Carrot had found them elsewhere, in the field, as it were, and adopted them. So they're not Carrot's own original work, and therefore depending of course on what variations she might have built into them, but in principle it seems highly unlikely that they're going to be considered to be original. There's also the pattern, which wouldn't be regarded as original because, again, it was taken from elsewhere, and the fact that it was taken from the automotive industry doesn't alter its originality, in principle at any rate. You might be able to argue on the basis of some of the case law, in particular the conservatory's case law, that you don't read across from the automotive sector to tableware when considering originality, and that's a point worth making to the examiner, but there's a much worse problem for the pattern anyway, which we'll come to in a moment. Finally, we need to consider the basic shapes, the shape of the cups and the saucers and the plates and so on in making up the tableware. And I think what you're going to need to say to the examiner here is that you would be wary about the possibility of these designs being considered commonplace. We don't know much about what there is in the basic design, and of course cups and saucers and plates are much of a muchness. Unless Carrot's done something quite radical with her design, then there's a strong chance that it's going to look like other plates and cups and saucers. Might still be original in the sense that it was Carrot's work, but if her originality has merely produced something which is commonplace in the sense that it looks like most of the other ones in the field, then the effort won't have achieved the desired effect, and there might not be any design right. So I think at this point you would tell the examiner that you know about the way in which the courts approach questions of commonplaceness, and you do that by reference to the Court of Appeal judgment in the Farmer Build case, which entails basically looking for features that appear in a lot or most of the articles on the market. The examiner is also clearly interested in exclusions from design right protection. First of all, the exclusion for surface decoration. So you need to explore the question of whether this particular pattern is going to be considered to be surface decoration or not. It's more than just a pattern printed on the surface of the plates and so on. It's something which has got a bit of depth to it. It's rough, according to the question. Therefore it exists in 3 dimensions. So I think you're going to be pointing to the cases where the distinction between 3-dimensional and purely surface decoration was explored. The examiner won't expect you to come to a conclusion, but you might well say to the examiner that you have a feeling that this isn't going to be regarded as anything other than surface decoration on the basis of the cases. You're welcome to come to a different conclusion. I don't suppose the examiner is going to be particularly bothered about which way you decide on this point, just so long as you've got a convincing argument about it. Finally, we've got must fit and must match. Features of the design which have got to be the way they are to enable the article to fit with another article of which it forms part, and features which have got to be reproduced in order to restore the appearance of a larger article. For the time being, I think we're just going to note those because we're going to apply them a little later. Next, I think we're going to tell the examiner what amounts to an infringement of design right. And we'll start with the statutory definition, which talks about reproducing a design for commercial purposes by making articles exactly or substantially to the design, or making a design document recording the design. Finally, apply what you've set out in the essay so far to the 3 infringers in turn. Again, I think there's no need to come up with conclusions, and any conclusions you might have are going to be tentative at best because you've only got very scant facts here. But at least show the examiner that you understand how to apply the law. So first of all, fuchsia. They appear to be substantially reproducing the cups. So if the designs of the cups are original, then there could be an infringement, but that's a big if. As for the handles, well, they're a feature of the design which have got to be disregarded because almost certainly there's no originality there. Turning to ebe, They seem to be making articles exactly or substantially to the design, probably exactly from what we're told. Their products are lower quality, but that's immaterial. The absence of the pattern is also immaterial. First of all, the pattern itself is not protected because it's surface decoration, we think. And secondly, whether the pattern's present or not, the shape or configuration of the cups and saucers and so on remains the same. Geranium, by their own admission, are reproducing the saucers exactly because they're making replacement ones. I think what the examiner is looking for here is for you to say Geranium might raise a must-match argument. But if they do, they're doomed to failure because they've misunderstood what must-match is all about. The saucer does not form part of an integral article. An integral part of another article. And I suppose it's not just must-match, it's also must-fit, because the recess in the middle of the saucer has got to be the right size and shape to fit the cup. Apply the definition of must-fit there. It works a bit better, because the definition doesn't talk in terms of being an integral part of another article. So what you're about here is explaining to the examiner that you recognise the issues and you know what they are. Ultimately, though, the answer to this question is going to turn on licensing of right. Section 237, tell the examiner what it says. It's not limited to spare parts type situations. It covers them, but it also covers any other situation where design right could be invoked. And therefore fuchsia, ebe and geranium can all take advantage of licenses of right if they're available, which we think they are looking at the dates. So your advice to Erica is forget it. You've had the period of exclusivity that design right gave you. Now at best you can get some royalties from these three people who want to use your design. So I've talked very little about copyright in that answer, and that's because I think there's very little copyright content in it. It's a much less complicated question than the ones that were being asked just a few years ago on design right, or on designs in general. Nor did I say anything about registered designs, and that's partly because registered designs are outside the syllabus. That hasn't stopped the examiner on at least one occasion. But if the examiner wanted you to talk about infringement of registered designs, he or she would certainly have mentioned some, and 8 years after the design was made and after articles have been sold, it's far too late to try and register a design, so certainly that's not what's on the examiner's mind. Anyway, the examiner specifically told you to look at the Copyright Designs and Patents Act, not the Registered Designs Act, so while I think it would be legitimate to say, well, Part 4 of the Copyright Designs and Patents Act did restate the Registered Designs Act 1949, that's rather pushing the point, and you could rightly accuse me of overthinking this a bit now. So I'll stop there. Hope that's been useful. Not a very difficult question, nothing to be scared of there. In fact, I think the main difficulty might be filling that out to occupy the time you've got to allow for it in the exam. Thank you for listening. If you like this presentation, then please give it a thumbs up. If you don't, give it a thumbs down, by all means, but please tell me why in the comments, and I'll keep on producing them and make them better if you tell me what's needed. Thanks very much. Bye.